Good morning, good afternoon, good evening. My name's Amy Porges, and I'm here to welcome you to the fourth in a series of conversations organized by SIEL, the Society of International Economic Law. Well, it's 2020, and all of us have learned to live with lockdowns, travel restrictions, and work from home. It seems likely that this is where we'll be through 2021 and maybe longer. But international disputes don't stop. So international dispute settlement must continue in spite of all these obstacles. For this conversation, we thought we would invite practitioners, including secretariat officials, litigators, and an arbitrator panelist for a practical discussion of what's happening in virtual hearings or other methods for managing trade and investment disputes in the pandemic era. I'd like to say thank you to my co-organizer, Freya Bottens, and to our moderator for today, Hugo Perezcano, who will now take the virtual gavel.
Thank you, Amy. It is a pleasure to be here and moderate this conversation. And I want to thank SIEL, especially Amy Porges, Marcus Wagner, and the organizers for inviting me to join this wonderful group of really top-notch experts. Now, international arbitration involves people, institutions, and other entities that are usually far away from each other. But at the time of hearings, they come together, and for a few days, sometimes a little bit longer, they're able to meet and focus on a case. In a world that we have seen, or that we thought that was shrinking, bringing everyone and everywhere physically closer, because it was easier and cheaper to travel faster and farther, we now find ourselves distancing and unexpectedly distanced. But technology has also played an important role in bringing us closer together virtually. Hearings are a fundamental part of the adjudication processes, and specifically of international dispute settlement. And in coping with the current situation, we have been forced to remain at the distance of the internet. So what are the implications for international dispute settlement and fundamental rights, such as the right to be heard, the right to present our case fully, both in writing and orally, the right to confront witnesses, fairness and equality, and the right to be present at a hearing? What are the hurdles and challenges of virtual hearings? What are the advantages? Since, at least for now, we have no alternative, how can virtual hearings be improved? So we are here today to explore these issues. We are going to focus on two widely used dispute settlement systems, the WTO and the investor state dispute settlement system. I would like to pose two questions to our experts, and I would like them not to respond to them immediately, but for them and our audience to keep them in mind as we move along today in our discussion. Are virtual hearings a temporary solution in light of the current situation that has us locked down, or should we expect that this will become the new normal where we are inevitably heading? And since for the time being, we have no choice but to cope with the current situation, whatever the answer to that first question was, what is desirable? So I want to turn it over to our speakers now. I want to say at the outset that each will be speaking in her or his personal capacity. Their views do not necessarily reflect those of the respective organizations that each is affiliated with, and what each says should not be attributed to those organizations. They are well-known experts and their bios are available on the SIEL webpage. So rather than introduce them myself, I would like for each to do so in turn and give us a brief overview of their respective experience with virtual hearings and how they have evolved so far. So Hara Mingus, can I turn it over to you? Thank you and welcome all.
Thank you, Hugo, and thank you to SIEL for inviting me to this fourth conversation. It's a great honor to be surrounded by such distinguished speakers. As Hugo said, my name is Jara Minguez, and I'm team leader and legal counsel at ICSID. I also act as tribunal secretary, and as such, I've had the opportunity to organize several remote hearings since the pandemic started in March. ICSID has had experience for a long time using remote means to bring in participants to some sessions or to even hold some short sessions remotely. However, when March happened and then suddenly we were all locked down in our houses, we obviously had to take it a step forward and make sure that we could host complete hearings remotely. We have come a long way, and hearings have increased in sophistication vastly during these last months. What we were doing in April or March almost seems prehistoric compared to what we're doing and what I had the opportunity to organize 2 weeks ago in a long hearing that I had to participate in. Since March, ICSID has organized over 120 remote sessions, and more than 10 or almost 20 were lasted 5 days or longer. We had even 3 or 4 hearings that were between 12 and 15 days. So, and this last one that I referred to was a 12-day hearing with simultaneous interpretation into 3 languages. So obviously it feels like real life hearings, and we have advanced a lot. And I'm very excited about today's conversation and learning more from our colleagues. And I, without further ado, give my turn over to John from the WTO.
Well, thanks Jara, and thanks Hugo for inviting me along to this webinar today. I mean, I think my comments are somewhat similar to Jara's in that even prior to the pandemic, virtual means had been at least partially used in WTO dispute settlement. We have organizational meetings with panel chairs beamed in by video conference or calling in by teleconference. There have been appellate body and panel meetings where participants have joined virtually because they couldn't travel to Geneva for a particular reason. But as Jara has just said, COVID-19 obviously led to much more significant disruptions across the board. Panels have been obliged to delay hearings or explore alternative means. Now, I would say at the outset that these alternative means are not limited to virtual platforms. For example, we've had a case where parties have agreed to replace a scheduled hearing with written procedures. In another case, a panel has decided in consultation with the parties to backload the hearing after 2 sets of submissions had been received, as occurs in compliance proceedings under Article 21 of the 21.5 of the DSU. But with the pandemic continuing in recent weeks, we've seen panels hold virtual hearings in 3 separate dispute settlement proceedings using the Cisco WebEx platform. In all of those 3 cases, we've proceeded in a hybrid way, making provision for Geneva-based participants to attend or participate via a conference room in the WTO. And I'd also sort of just like to emphasize that WTO members themselves have a diversity of views on the whole issue of virtual hearings. Some members are very supportive of panels advancing in this area, others are not, and that doesn't necessarily reflect complainant or respondent status, as you can have instances where both a complainant and respondent may prefer a delay rather than a virtual hearing. Of course, in all cases under the WTO DS rules, panels have to consult with parties before determining the most appropriate course. So in short, the WTO is still in the early stages of utilising virtual means. But I think it's fair to say so far panels have had a fairly positive experience with no significant technical hitches in achieving what they set out to do in providing an effective opportunity for the parties to be heard in circumstances where a physical hearing was not possible. Finally, because I didn't say it at the outset, I have been the director of the Legal Affairs Division for the last 4 years. Prior to that, I worked with a WTO member government, New Zealand, where I was involved in dispute settlement proceedings over a number. And I will now with that pass it on to Martin.
Thanks, John, and thanks, Hugo, and thanks CL for the opportunity of being here with everybody today. So good morning, good afternoon, good evening to everybody who's watching. My name is Martin Doe from the Permanent Court of Arbitration, Senior Legal Counsel there. Also, like Hada and others, advising both the institution and the tribunals that are hearing cases under our auspices. And I think I will say some fairly similar things. I think digital communications and digital collaboration was already de rigueur in our cases pre-pandemic, but during the pandemic, it really accelerated, I would say. And then even though we had done a whole lot by video conference before March, when March came around, we were really forced to try and transfer the entire proceedings to be fully virtual, even considering things such as that the interpreters were not able to get to a proper interpretation booth and had to provide those kinds of services within the hearing. In terms of numbers, I'd say we've held about 50 sessions that could be properly called hearings, and about an equal number of sessions that would be a little bit more limited there since March. I'd add that in September, as people may suspect, we had a little bit of a tilt back towards in-person sessions, in particular where all the participants were able to participate from the Schengen area, and in fact also in our Mauritius office. There, Mauritius happily staying COVID-free throughout this period. And I'd say what we've faced most is this arduous debate that is still ongoing about whether or not virtual hearings can be held against the wishes of a party. And there's where I'd say, well, the balance of authority for now, and Hada is right to say everything's changing even day to day, says yes. The Austrian Supreme Court just this week ruled yes, and national courts are having trouble saying we've embraced virtual hearings, but we're going to chastise that when other institutions do so. But I'd say it's still a case-by-case analysis. It depends on the circumstances. It's still not settled, and especially so for international courts and tribunals. And in that respect, I think our neighbors in the Peace Palace, the International Court of Justice, had quite a big debate before they took the leap into the deep end with their first virtual hearing, which I think then went swimmingly. So I think with that, I will pass the ball to Philippe.
Thank you. Thank you, Martin. So my name is Philippe Sellard. I'm Senior Legal Advisor at the Permanent Mission of Canada to the WTO in Geneva. Canada is a frequent user of the WTO dispute settlement system. Canada is also a participant to the multi-party interim appeal arbitration arrangement that protects the participants' rights to a two-tier binding dispute settlement. Virtual hearings, the hearings per se, are a relatively recent phenomenon at the WTO due to the pandemic, even though, as John has mentioned, there were a few cases before where at least one panel member or one appellate member appeared through virtual means. But the whole hearing being organized virtually, it's a fairly new development. Canada has not been involved yet as a party into virtual hearings, but we have been involved as a third party in a few virtual hearings. Thanks to the excellent work of the Secretariat, done by the WTO Secretariat, we've not faced any significant difficulties there. So there, from a technical standpoint, went very well. There was a lot of preparation done in advance. So when came the day of the hearing, everything went very well. As a third party, I think our hope would be that in future virtual hearings, there's more interaction between the third parties and the panel through questions and answers, so that we get to a point where it's very close to the experience that we would have at an in-person hearing. But overall, our experience has been good, and we're confident also that in the future, things will go well from that standpoint. And we also agree with the statement that, I mean, every hearing and every case, parties will need to talk together and with the panel members as well to determine what's best in a given in a given dispute, because as we will discuss later today, I suspect, obviously disputes varies and the proceedings or procedures may have to vary accordingly in terms of how, which type of virtual means and how proceedings will proceed overall. This being said, I will ask Cherise to say a few words.
Thank you, Philippe, and thank you to Hugo and to CL for inviting me to participate in what really promises to be a very interesting webinar. My name is Cherise Ballas. I'm Deputy Director at the Advisory Center on WTO Law. We are currently advising several parties, both in their capacity as complainant and as respondent in several disputes. And we have engaged in, hearings post 16th of March in a variety of formats. So the first hearing that we did, it was the second hearing in the dispute. It was entirely by written procedures, which in fact turned out to be a lot of work, because everything you have to say, you have to put in writing. And sometimes the deadlines are quite tight for those submissions or comments on submissions. In another case, we had a hybrid hearing in which some parties were in the room, limited numbers in the room in the WTO, and then others participating virtually. And in the rest of the cases that we are involved in, we are currently trying to determine the format of either the first or the second hearing in the dispute. And in some of the disputes, this issue is complicated by the fact that there are multiple complainants in different time zones, or there are several experts also in different time zones. So these are the issues that we are grappling with, and with the parties, of course. And as John mentioned, there is a diversity of views among WTO members as to how best to proceed. And of course, the panels have to take into account the views of the parties and then try and come up with a good solution. And, that's the process that we find ourselves in now. And we will see how things transpire in the future, especially in the light of the, increased spike in cases in Switzerland and in other countries around the world, in which the issue of even perhaps hybrid hearings at the WTO Secretariat, which involve in-person attendance, may, even with limited numbers, may be an issue. But I will leave my comments there and look forward to the discussions.
Thank you. Well, I just want to remind our speakers as we get into our conversations to be mindful of the time. So if you at some point see me waving frantically, that means it should be time to move on. No offense to the speakers or the audience. But you've each spoken of your experiences, but in WTO and investor dispute settlement are two widely used systems, as I was saying at the outset, but there are important differences. Without underestimating the complexity of WTO cases, I personally, both as a participant, as a party to a case, as a panelist, I've always viewed them as desktop cases. They can be essentially prepared, studied, and decided from your desk, provided that you have an internet connection, and it doesn't have to be as good as for virtual hearings. But a connection that will give you access to the material and research resources. facts are more straightforward and not often contested. ISDS is quite different. More often than not, the views of one party are diametrically opposed to the other. Those of the other party. You have to go out on the field to gather evidence, interview witnesses, prepare your case. And of course, arbitrators need to hear both the parties as well as their witnesses and experts. So what role do virtual hearings play in these two different settings? And I think the same could be said for other types of hearings, for instance, jurisdictional hearings as opposed to hearings on the merits, jurisdictional hearings where the facts are not usually contested, or hearings on appellate review or annulment proceedings that deal more with issues of law than questions of fact. John, let me turn it over to you.
Yeah, well, thanks, Hugo, because I think that's a really useful introduction here. And one of the great benefits of participating in these webinars is that it broadens your horizons, because I had to sort of read into some ISDS decisions recently in preparation, just to get a sort of a good contrast with, the nature of work within the WTO. And it's pretty clear that there is a strong contrast between the nature of the proceedings in ISDS and WTO. I mean, ISDS, I think you deal with a lot more procedural or jurisdictional issues. You have significant witness testimony with cross-examination. Both fact witnesses and experts on, technical issues like valuation and damages. The active representatives at ISDS hearings tend to be a lot more than at WTO hearings. There seems to be a greater need to consult record evidence on the spot in ISDS. And as Hara has just reminded us, they're often very lengthy proceedings, 12 days. I don't think we've had anything quite like that in the WTO. So in contrast, the WTO proceedings, and I think as you've sort of hinted at this, they tend to follow a more circumscribed or predictable pattern of reading of opening submissions, a structured Q&A, and reading out closing statements, all taking place over a couple of days. And it's relatively rare in WTO proceedings for panelists to interrupt, for example, parties when they're making their opening statements. But my understanding is that in ISDS, that happens quite often. So I guess one of the things that really struck me in preparing for this discussion was that the success of practical arrangements for virtual DS proceedings is very much dependent on accommodating all the moving parts that make up the process. And obviously that's all the parties, all the panelists, or tribunal members in different locations and zones. But I also think the additional procedural complexities and other aspects that characterize ISDS make for a more challenging environment than the WTO DS environment. When we've had discussions with our ICSID colleagues this year, they referred to the need to, some people want 4 screens in front of them, whereas we've found in the WTO sort of context, based on our limited experience, that people can get away with just, maybe a split screen or even 2 screens. Basically one screen that gives them access to the WTO e-filing DORA portal and one to the meeting itself. So I guess I would sort of have a sense that it's more easy to manage WTO DS proceedings through virtual means than may be the case with ISDS, just given the range of more complex sort of moving parts and issues that you face in those proceedings. Thanks, and I'll pass on to Martin maybe for additional comment.
Thanks, John, and I suppose I think we stand as a good example of the ability to take remote hearings, video conference hearings to all sorts of different cases. We've seen our interstate cases, our ISDS cases, and even cases that are brought under contracts that are administered under our auspices have all seen virtual hearings happening on a fairly regular basis since March. And as I said, our neighbors in the Peace Palace, the ICJ, have also seen virtual hearings happening there in a different context. But I'd agree with John that it really is when you start to add more moving parts, and in particular when you start to add the fact finding and the witnesses to the equation is really where the rubber hits the road. But that's where I'd say we have yet to find a situation where it's impossible rather than a question of what's ideal or advisable. There's a number of concerns that are leveled sometimes. The old common law phrase, I want to see the whites of their eyes. Well, now you can do so in 4K high definition and throw on instant replay to see what you think of the answer that a witness has given there. And frankly, I think it's obvious enough when I'm casting a glance up my notes right now that I don't think witnesses are likely to get away with the kind of prompting and coaching that people are usually afraid of. In fact, I used a teleprompter for another webinar, and I have to say that went atrociously. So I think witnesses would be well advised to stay away from trying to play fast and loose. I think cybersecurity has been a big concern there, and of course that comes up in fairly generalized fashion, but even more so when you start to talk about highly sensitive business information that might feature in a hearing. But there's where I'd say we've been dealing with exactly this issue for years in the ISDS space, and have always been able to find a good solution and have found solutions in each case as we've faced it in the course of the pandemic. And in fact, I think the pandemic has made people a little bit more realistic. We've had some cases where a party, or even the parties together, or one of the arbitrators has said, sure, we can hold the hearing on Zoom, but I don't want to deliberate. I don't want our deliberation sessions to take place on Zoom. And yet it's become a lot easier to say, so how should they take place? Unsecured email? Telephone? Those are actually the weakest links in the cybersecurity chain right now. And I think we're getting some much more realistic conversations as of late. And I say that from an organization that was very hesitant to anything that had the word cloud appended to it until fairly recently. And I think this is where I'd say it's interesting, because the legal frameworks and the procedural frameworks that we've used have all had quite explicitly that video conferencing can be used for witnesses, even when they didn't say that for the hearings themselves and for the actual oral submissions. And I'd add to that again, hearkening to sister institutions in The Hague, the international criminal courts have been doing it for well beyond even ourselves in the arbitration space, and with a much stricter standard of due process. So it becomes hard to say why we can't explore the options and find the solutions where they're actually needed for each individual case, without ignoring that there are challenges. And with that, I think I'd pass it to Jara, who I think could probably expand on almost all of that.
Well, instead of expanding, and due to the time constraints, I'm just going to agree with everything you said and say that our experience has been very similar. And indeed, like the more moving parts you have, the more complicated it's going to make the remote hearing. But we have yet to find one that's impossible. To be realistic, and just to like one thing that I do think is a handicap, and maybe going back to Hugo's question at the beginning of like what's going to happen in the future. There are some hearings where the time zone difference, or where if it's a more than 12-day long hearing or something like that, you may have to go and meet in person, not because it's not possible to do it remotely, but simply because everyone is exhausted. And if you can't have people in Asia working overnight for 3 weeks, and people in the US waking up at 4 in the morning for 3 weeks. So it won't be because the remote means don't allow it. It'll just be because we're humans and we do have some nature needs. But all in all, I think that we've really made remote hearings like a convenient and a useful tool. And I do hope that in the future we will continue using them for those cases where remote hearing is appropriate. And I'll pass it on to Philippe.
Thank you, Hara. I would like to just mention that I think that what our experiences have taught us so far is that there are definite advantages to having virtual hearings. I think that you know, sometimes when you're actually in the room, you tend to get distracted by other things going on. Whereas when you're on a virtual platform and there's just somebody speaking and you have to focus on what they are saying, and I think that that is a real advantage, actually. I think that there are, however, also some disadvantages. So we know that when we have hearings at the WTO, there's a very strict list. You know, you have to send your delegation list in advance. You are monitored when you come into the building. You not just anybody can attend a hearing. When you're doing a virtual hearing, while the platform itself may be very secure and confidential, there may be concerns that other people who are not necessarily you know, listed on the delegation list may be able to listen into those proceedings. And so I think that one has to also, you know, examine those issues and see how one can resolve that. I think that the issue of the length of the hearings does also arise in WTO proceedings. I mean, John is absolutely correct that most of the hearings are for a fairly limited number of days. But sometimes if you have experts, then you also have to have meetings scheduled with the experts. Depending on the time zones, you know, you may have to have those meetings scheduled over a few days. Then you have to have the meetings scheduled with the panel and the parties. So that would be also for, let's say, you know, quite a few days. So you're looking at maybe 8 days of hearings, or at least, you know, encounters with the experts and the panelists. And therefore, I mean, we're talking about a long period of time to be online, you know, trying to give your best in this virtual format. So I will end my comments there, but maybe we can pick up on some of these other issues later on.
Thank you, Cherise.
Thanks, Cherise. Yeah, Philippe, I was going to ask you
Yes.
to give us your remarks.
Thank you, Hugo. I wanted to come back to the issue of the distinction that can be drawn between ISDS and WTO dispute settlement, and distinctions also that can be drawn between the appellate review and the panel stage. The proper determination of facts and scientific evidence can play a central role at the panel stage from time to time, while questions of law obviously are central to the appellate stage. I think there's also an additional distinction that can be drawn between trade remedies cases, where issues of anti-dumping, the application of anti-dumping duties or countervailing duties are at play, and other cases. So trade remedies cases represent an important portion of WTO disputes. In such a case, the panel will normally examine a determination made by the investigating authority of a member. So in such a case, the focus of the examination will typically be on the statement of reasons of the investigating authority and on the record of the investigation, not really on making additional findings of facts. As such, it seems that this is the type of case that lends itself particularly well to virtual hearings, given the nature of the functions performed by the panel, as opposed, for example, to a case where a panel has to examine for the first time scientific evidence presented by an expert. As I have mentioned, appellate procedures would also seem to lend themselves especially well to virtual hearings, given their focus on questions of law. Speaking of appellate procedures, as we all know, the appellate body is no longer able to hear appeals due to a lack of quorum. In the meantime, and to ensure continued access to two-stage binding dispute settlement, 24 members of the WTO, including Canada, participate in the multi-party interim appeal arbitration arrangement. A pool of 10 arbitrators has been established to hear appeals, and appeal arbitration agreements have been signed in 4 disputes, but no proceedings under the MPIA in any of those disputes have taken place yet. However, I think that one can expect that participants that have expressed their support for the dispute settlement system through their participation in the MPIA would also be open to adopt means such as virtual hearings to ensure that proceedings can move forward in difficult times like those we are facing today. Moreover, by the time a hearing happens under the MPIA, participants may benefit from the accumulated experience with virtual hearings at the panel stage. Finally, I would also like to note that 14 members, including Canada, have made a statement aiming at minimizing COVID-19 disruptions to the dispute settlement system. The members are flexible alternative arrangements and welcome the fact that panels have held hearings virtually. This again illustrates the willingness of many members to ensure that disputes progress in a timely manner despite the current challenges. Thank you, Hugo.
Thank you all. And you've all referred to, the technological challenges and advantages. But so let's turn a little bit to that. As I was watching one of the webinars organized by ICSID and Hannah, who's here with us today, I recall one of the speakers saying, everything you would need to ensure that you were properly participating in a virtual hearing. So John said it as well. 3 monitors, somebody said no, not 3, 4 monitors, a couple of laptops, 2 iPads. You have to ditch your old phone and get a new one so you can have WhatsApp to communicate with your colleagues, a separate platform. Anyhow, as I finished watching that presentation, I was ready to go out and buy myself all this gear. I told my wife what I was up to, and she just said, have you really gone nuts? I mean, we have tuitions to pay, there is the rent, and we want to go out for dinner on the weekend. So, of course, the ideal is probably very hard to come by. My question to you in terms of actually being at a hearing and effectively participating, whether as a party and advocating your case, or as an arbitrator and hearing what the parties, what the witnesses have to say, the documents that they want to show you in a shorter time frame. What is the minimum requirement? And more importantly, what happens when somebody cannot procure it? And I'll give another example. Today, because of the platform that we're using in serious security concerns, I'm confined to using the old tablet that nobody uses anymore. So I had trouble logging into our webinar today because there is no email, so I could not just forward myself the link to the meeting. So it brings these complications. What does that do to a party who wants to present its case fully and in a way that the party feels comfortable the arbitrators are getting what that party wants to say, and what arbitrators, what do they need to effectively hear the parties. And again, here I find differences between ISDS and WTO. In WTO hearings, normally the parties give you their opening and closing statements in advance. People read them throughout the hearing. In ISDS, people rely heavily on the transcripts. It is much more dynamic. So what can you tell us about these technological hurdles, and what is the minimum? What happens if you cannot come by that minimum? Let me turn it to Jara, who is very much experienced in this area.
Thank you. Well, Hugo, I would say that obviously if you have the whole NASA behind you, you will have a great experience, but I don't think that's the minimum, and you can have a great experience in a virtual hearing without any of that. The bare minimum is a good internet connection, and that's more for peace of mind than being the bare minimum. In all my hearings, there's been a moment where someone's internet has fallen through, and once, for example, it was mine, and I had to continue listening to the hearing from my phone using my 4G connection. So even a good internet connection could be overcome. But for peace of mind, a good internet connection is definitely what you need. And then adding that onto that, you'll need some kind of screen. It could be your phone, but probably a computer is best. And it will really depend on how complicated or what is happening during your hearing. Do you have a transcript? You'll need some space for that. Are you going to be looking at documents online? Then you'll need some screen space for that. And depending on how much you add to that, you will need more or a bigger screen. You could have a huge screen and maybe one is enough for everything. But I would say that 2 screens are very easy, very convenient. And obviously when I did my first hearing, we were all confined at home. Even counsel team were all separate. So they did need to find ways to communicate. As things have gone forward, like now you see that teams of counsel are clustering in different locations. So they can obviously communicate better and then don't need extra screen space for that internal communication. But you do need some setup. But it's what we have done in cases where parties have not been able to secure that optimal setup is that we've been able to rent that laptop and 2 additional monitors and ship it to them and then guide them through the setting up process. So there are ways to overcome that kind of challenge. And I would say that's my view now on the technology. And I'm sure that others will add to this. I did want to come back to a comment that Charisse made earlier about the possibility of people jumping into the session or appearing and the lack of security. And in our experience, what we're doing is that we have first the platform is password protected. And then once you have that password, you still have to go through an additional screening. We have a waiting room set up and no one can come in without going through that waiting room. And there you will check their names and you won't let anyone come in unless they have their name. So this double layer of security has proven very efficient and we haven't had any surprises in hearings so far. Thank you.
Philippe, what about you from a government's perspective? Governments have, well, Martin and others have referred to cybersecurity, and governments have various sensitivities about what information can be shared, what platforms they can be on. What can you tell us about the necessary technology in that respect from that point of view?
Thank you, Hugo. Well, first, I think that obviously connection is very important, and equipment also is very important. One may think that some government with significant means are in a favorable position, and they generally are, but they still face challenges. So even before talking about the platforms and the rest of security, there's sometimes an issue, strangely enough, about internet connection, for example. There's a number of civil servants that are still working from home. So while they may have a good internet connection at the office, they may not have as good a connection at home, especially if they live in the countryside. So it may mean, for example, that especially when using a platform that requires a broad bandwidth, such as Interpretify, they may have to go to the office. It happened to one of my colleagues recently. Issues with respect to security is also, as you pointed out, can also be an issue. So I think there have been developments, as with the rest. Initially, there was some significant reluctance with respect to certain platforms, but now I think the organizations themselves, like the WTO, have selected some platforms that we found are secure, and we don't have a problem with using those platforms. I know that for some other governments, there are still issues with using some platforms, for example, for security reasons, as you indicated. And this is a challenge that remains, because sometimes with their government-provided equipment, they cannot access certain platforms. And that I know for a fact, from speaking with some of my counterparts here in Geneva, is a real issue that some delegations are facing. In addition to this, as we've mentioned, oftentimes we will need another platform or a secondary channel in order to be able to speak with your colleagues within your delegations, or the expert, or an outside counsel. So that adds to the complexities with respect to managing the electronics or the IT equipment. Thank you.
Thanks, Philippe. Charisse, you deal a lot with developing countries, and these developed countries that just because of their level of development often have a hard time accessing the dispute settlement system on its own. Forget about the pandemic and technology. You know, and this is, by the way, I remind our audience that we do have the capability of seeing questions that you pose. So I encourage you to pose some questions if you have been coming in. But going back, one of the members of the audience said, you know, internet connections are different in different countries. And this may pose a challenge, especially as Philippe was saying, where, you know, a government official may have to be at a hearing at home with a poor internet connection, that there's really nothing to be done about it. How to upgrade your home system. Among the things that I was telling my wife, I wanted to rack a couple of walls so I could have direct access to the modem, and that didn't go well. You know, Hannah said we've rented equipment and shipped it. Perhaps larger companies, sophisticated governments or law firms may provide the equipment to their advocates, but it may not be the same government-based procurement or restrictions, rather. How do these issues play with less developed countries?
Thank you, Hugo. Yeah, I think that's a valid point, and I think that there are many developing countries that have complained that they are not able to participate virtually because of, you know, the difficult technological and infrastructural disparities in their country, and you know, lack of bandwidth, which is now the most important thing. But having said that, I don't think that it is only the developing countries that have objected to having virtual hearings. There are developed countries that have very good infrastructure that have and bandwidth that have objected on the grounds that these do not constitute a proper hearing, virtual hearings. And the issue then becomes, is there a format for hearings that is, you know, designated in the dispute settlement understanding? And of course, we know that there is not. And, you know, the DSU allows the panels in consultation with the parties to deviate as necessary, you know, provided, of course, that there's consultation. So I think that that's a very important issue, this notion of consultation with the parties, etc. Another point that must be raised is in the factual context that we find ourselves in Geneva. We have a situation in which some people from some countries can travel to Geneva without any quarantine, and others cannot. And therefore, if one is offering a hybrid hearing, let's say, where you offer participation to some, is it really a due process because you have a situation in which, you know, some parties are subjected to greater burdens than others? And I think that that is something to be taken into consideration as well. I don't know if there are any hard and fast answers, but it's something that has to be taken into consideration. And lastly, with respect to the issue of the second platform, I think in many ways, you know, we were doing this even in in-person hearings because it's always easier to communicate, you know, with other lawyers on your team or with the client without having to lean over and you know, physically ask questions or seek detailed information. But I think what's really important in a hybrid situation or a virtual situation is that you use different platforms for what you are having the hearing on and what you are having your you know, in team discussions on, because you really don't want to have a message, you know, sent to the whole panel and, you know, the other party, you know, etc., that is inappropriate or gives away confidential information. So that's a very important point, I think, to keep in mind. Thanks.
Thanks,
I might jump in.
Let me, yeah, but before you do that, because there's a question that has come in, and I actually wanted to ask both Martin and John to try to respond to it. One of the questions is, Martin, you referred to you know, the teleprompting and trying to prompt or coach witnesses, and that certainly wouldn't go well with the virtual hearings, since you can probably see the teleprompter reflected on their eyeglasses. But one of the questions was, what about documents? Is there a concern that documents may be, you know, manipulated using or taking advantage of virtual hearings? Is that a concern? And in a similar respect, in terms of documents, and John has already referred to DORA. DORA is a very secure storage system for WTO documents. Panelists have access to them, members have access to them. Certainly the whole WTO staff has access to them, but it is very secure, and there are security hurdles. We need to have our tokens, our passwords. We need to change them every so often, and that not only takes care of storing the documents securely, but certainly you know, having access to the documents that are on record, if that were a concern. So with that, let me turn it back to you, Martin, if you can address this as well in your remarks, and we'll turn it then to John.
Sure. I was going to start by agreeing with Cherise's comment that I think now the errant reply all chat has joined the errant reply all email as a threat to all of us in this space. As to documents, and frankly, as to the broader question, I think this digital divide is as Cherise was alluding to, is not really a north-south dynamic, or not exclusively a north-south dynamic, but really goes to all sorts of different contexts. But it's not something that we've really faced as much as we expected to along the way. Documents, as I said, it's easy enough to find the right tool for the right case to deal with it in an appropriate way that scales with the sensitivity of the information there. And I think as to what you were talking to and alluding to what Cherise was also saying before, there's some things that are actually already major improvements here, but it's like any shiny new toy, it's easy to overdo it. I mean, I've had 5 screens, 6 screens in front of me for a good portion since of the time since the spring. But instead of giving me superpowers, they really are just dividing my attention to all sorts of different places and taking away that advantage that Cherise was speaking to. So I think got to be careful not to overdo it.
If I could come in and just respond directly to the point on documents. I mean, it's really to reinforce, I think, your point, Hugo, about how we now tend to share documents in the WTO dispute settlement system through the DORA platform. I mean, I think that's been a huge advance in basically leaving everyone confident that there is a sort of a secure means. It's become like a library that's available to all panelists, to all the parties involved, of all the submissions. So if they want to, you know, sort of upload a document that comes up in the context of a proceeding, there's an easy way to do that, and it's on hand. And so I don't think that there's a real sort of security problem as such in relation to document manipulation, because of all the work we've done to try and avoid that. Just another couple of comments on this technology thing, because I do want to say that I agree very much with Hara when she said, you know, at the basic level, you know, a good internet connection is what you need, and then you build up from there in terms of the number of devices, depending on how obsessed you are with devices or reassured you are with devices, I guess. But there is one thing that I think is absolutely crucial, and this is an area where we took advice from ICSID at the beginning of the year when we reached out to them, was, you know, the need to have effective preparation through testing, basically, before you go in to the actual sort of hearing, you know. And I saw this very clearly in the context of, you know, general WTO meetings, WTO committee meetings, which were using virtual procedures. It was very clear in the early days of using things like Interprify that, you know, members found it very, very difficult to understand that they would actually have to follow, you know, the letter of the instructions that was sent out about, you know, don't use this particular sort of browser, use this other browser, etc. And it took a lot of sort of stumbling through to get to the point where we now have relatively trouble-free meetings. But the first few meetings were, you know, pretty painful to go through because, you know, very senior ambassadors were not appearing or being cut off. And likewise with, you know, virtual hearings and dispute settlement, I think that having those test sessions, making sure that there's a means for people to know, you know, who they can consult if they're facing a problem, that's absolutely crucial. If you do that in advance, everything else, I think, seems to fall into place. Thanks.
All right, let me turn to another topic that you have all referred to in a way, and this is time zones and what it does to a hearing. The one thing that it does, and you know, the farther people are apart in terms of time zones, the more complicated the problem. But I'm heading into a hearing in a couple of weeks, a WTO hearing, where a usual hearing that would have taken you know, a couple of days, 6 to 7 hour long days, it has been reduced to by half, to a couple of days of 3 hours. And this is just because I need to wake up not very early, but quite early, and one of my colleagues, and literally on the other side of the world, needs well, he would prefer not to go on for too long because he has to go out and party at the nightclub because it's going to be that time. But this affects not only the times of the hearing, but you know, I may be at my peak performance early in the morning, or I may be at my peak performance later in the day, and I may not have that choice. Witnesses, it may be difficult to question a witness because of the time of the day, or it may be an issue with how long can we pose questions to a witness. So it raises all sorts of issues in you know, questions of fairness, question of equality of arms. Hara was referring to, you know, you cannot have people waking very early in the morning, many of whom I usually, whether I'm advocating or sitting as an arbitrator, I usually wake up early in the morning to go over my notes, prepare, and come into the meeting fresh. But if my meeting is starting at 7 o'clock in the morning, that may be way too early for not for me, for anyone. So, you know, this affects the attention span, your peak performance, and other questions. What can you tell us about these issues? And you know, from a government's perspective, Philippe, can I turn to you and what you tell us about that?
Yes, thank you, Hugo. That is a challenge that is very difficult to resolve, actually. And instead of trying, one has to adapt in a way, and maybe to adopt some strategies, because in the WTO context, as we all know, you may have representatives of parties and decision makers that are located in widely different time zones: America, Europe, Asia, Oceania. Situations sometimes may become even more complicated when third parties are involved as well. It results, as you've said, in people having to participate either very early in the day or very late at night, which is far from being ideal. And when time zones vary so widely, then you end up having reduced hearing times. And that's something we would face as well when representing the government. So I will refer to 3 moments in time where this issue, I think, may be addressed in a way to try to limit to mitigate the effects of those variations in time zones. First, at the time when the decision makers are selected, one can imagine that that could be one of the criteria that is being looked at, for example, by the WTO Secretariat, in considering people to sit on a panel. That's one possibility if you've got people who are located in the same time zone as the parties, or in a way that basically it can increase the time available for a hearing. That's one way to mitigate effects of time zones. Then the problem, though, is the downside is that it could limit significantly the pool of people from which you can select, and sometimes it's already difficult enough, so you don't want to limit any further the pool of people you can select from. If the time zones remain an issue, then another moment in time when you can address that is before the hearing. For example, by asking questions in advance of the hearing and asking for answers in advance of the hearing, so as to focus basically the hearing on the issues that are central to the case. And that is something that can be done, or could be done before. That was sometimes done by panels, but I think it becomes even more necessary or more useful sometimes, in this case, when you don't have as much time to hold a hearing. And then the third moment in time is at the hearing itself. And we've all seen some hearings that were long hearings, still having the impression that we won't have enough time. Then the panel members have to be more active in asking and kind of focusing against the debate by asking certain specific questions, by telling a party that they've heard them on a given argument that is being repeated. So I think that this is something that the panel members will have to do more and more when they don't have a lot of time to deal with at the hearing. This also emphasizes the advantage of having an in-person hearing, because it's good to have everybody together. People are rested and they're there for 6 hours or 7 hours. That's a very significant advantage. but unfortunately is not necessarily available these days. But yes, control is one way at the hearing to address these issues with virtual hearings, I think. Thank you.
Thanks. We're coming close to the end of our session. So we'll continue to discuss this topic, but let me try to pose a couple of questions that have come in, not necessarily related to the time zones, but if you can address them, so we can respond to our audience in a way. There is additionally, one of the participants has asked, what about the cost? Are certain countries, and not necessarily developing countries, but certain countries shooting themselves in the feet or in the foot because, because virtual hearings may actually be more cost effective. Well, one question is, are they? But it may be more cost effective. So is this one consideration to take into, or one thing to take into consideration? Another question that has come in, and it really goes back to one of my questions at the outset. So it may be appropriate as we sort of head towards the end of the session to say, are virtual hearings here to stay? My sense from having heard you is yes, but they are not a substitute, and there will be times when they are more convenient, but I would like you to address that as well. And so let's come back to the issue. Martin, you've dealt with many time zones. What can you tell us about this?
I'd say that it's very much a double-edged sword. Again, I mean, as Cherise was alluding to before, you can have, you need to have a shorter hearing because of time zones, but that means a shorter, more focused hearing, hopefully paying greater attention. But the fact is, because of the medium, it's actually more fatiguing, and you won't be able to last the 6 or 7 hours without starting to have your attention span wane. On the flip side, I've already faced quite a number of situations where the question would usually be posed, should we have a hearing at all, or can this be dealt with on the documents? And the answer to that question now is, why not? It's a couple clicks of a button and so on and so forth, and we can all get together and discuss it. And saying, okay, well, how about this part of the hearing? We'll do the opening statements and the witnesses, and maybe we'll wait a week for everybody to catch their breath, process what happened there, and come back for closing statements. And questions can be sent to counsel in the interim to actually make the closing statements that much more useful. And a slight accessory point of that is I've seen bigger and bigger delegations, in particular all the junior lawyers who used to get left behind for the hearing are now able to be there and participate and get the benefit of that. And I think that's another slight accessory benefit of the times that we're living in.
Let me turn over to you, John, and add one question. One of the participants in the audience asked, is the WTO mechanism still fit to provide effective remedies? Now, that's a larger question, but I would rephrase it, is going into this virtual hearing world, for instance, can it prompt some sort of reform to the WTO mechanism that is needed in many other areas, but can this be at least in terms of meetings and hearings and in sharing documents and information, can it be useful time in that respect as well?
Yeah, well, I mean, just on that question, I mean, as you say, that whole issue of you know, what's the state of effect of WTO dispute settlement, that is a very big question at the moment, given the situation with the appellate body. And it really depends very much at the moment on, you know, the preparedness of parties to basically agree, I think, on whether they're going to, you know, agree to a process that basically would allow for an effective end to the dispute to take place, even without the automaticity of the appellate body. Now, it can, you know, some of the discussions around virtual hearings sort of assist with issues to do with WTO dispute settlement sort of reform. I think that depends very much on where members want to take some of these issues. I think that, you know, some WTO members have made it clear that as a general practice, they will be amenable to virtual hearings in the interests of advancing, you know, WTO dispute settlement as a feature of the system. But, you know, members have different views on this. And I think the whole agenda for WTO sort of reform it goes much further, I think, than anything that we can sort of cover off here. I did, just on this issue, coming back on this issue of time zones, just want to say that, you know, I'm from New Zealand, so my life has been punctuated with phone calls at strange hours of the morning with people surprised at the time that it is in New Zealand when they wake me up at 2 or 3 a.m. But you know, the thing that I think you're really compelled to do in this sort of virtual environment is be flexible. You've got to be flexible. You've got to take into account, you know, the fact that there are a range of players who have different, you know, times there, and essentially that does call for things like, you know, maybe shorter periods dealing with distinct sort of stages over a longer period of time. I think that will come up as a proposal to expedite the process. Finally, just to say, you know, are they here to stay, virtual hearings? I think it's pretty clear that members, even, you know, the members who are most supportive of virtual hearings in the WTO, I think have made it clear that they see a physical hearing as the most desirable option if possible. I think it remains to be seen what our experience through this pandemic, where it will take us, and what will apply in the aftermath. I think we have to wait and see.
Hugo, you're muted.
Yep, thanks for that. That is one of the things that happens with virtual hearings. That's, but as we're coming to a close, I'm going to turn it over to you, Hannah, since you seem to be, given the numbers that you gave us, you and the ICSID seem to be probably the most advanced institution in terms of virtual hearings. And so if you can come back to the question, you know, what is the outlook for the future? And one of the first questions that came up was, what about force majeure and hardship clauses? Of course, that is a larger question, but is this something that could be invoked, for instance, to avoid having a hearing or avoid appearing at a hearing? Or, you know, is this something that could disrupt? Has it been an issue in your experience?
I mean, I've seen a lot of things invoked to avoid appearing at a hearing at the beginning of the pandemic, but that has not been invoked yet. I'm going to close on a positive note, and I'm going to say that in my experience, I've seen a party that was represented by counsel in one case adamantly and arguing everything you could imagine oppose a virtual hearing. And then that same party with same counsel, after having gone through the virtual hearing, come back in another case and ask the tribunal to like, please just schedule a virtual hearing, it's fine. So that's what speaks to me, and that's what really shows that it's not just a necessary solution, it's actually providing a useful tool. And even though I agree that at some point in-person hearings are obviously preferable in some situations, I think there will be a situation for remote hearings, and that we will still see them after we can start to travel again. And I do hope that soon, because not just for hearings, but just to go and see my family. So I think we will, I think we will learn from this experience, and we will be using this tool to help us in the future. Save costs, save environmental costs, and also hopefully save printing of documents, which saves a lot of space and a lot of trees. Thank you.
Well, this really brings us to the end of our session. It has been hugely interesting. I'm only sorry we don't have more time, but maybe we can ask SIEL to invite us again for some coffee and cookies and continue this discussion some other time. So with that, I want to first and foremost thank the 5 of you for your insights, for participating in this very interesting conversation. Thank the audience for being here and asking questions, being attentive. We hope that we have provided you with better tools to understand and figure out how we go into these hearings during this trying times, and as we have heard, most certainly afterwards. So with that, thanks again to Amy, Marcus, and SIEL, and we'll close our session here. You have all very good morning, day, and night. Thank you. Goodbye.
Thank you.
Thank you.
It's been a pleasure.
Thank you.
Thank you.
Yeah.